Read the second time. The honourable member for Nelson.
Thank you, Mr. President. Well, here we are again. Feels like taking another hammer and chisel to chip away some foundations of our planning system, it seems. This week that's been the theme. And this time the chisel is this piece of legislation from the government, which I regard as ill-conceived and rushed. And I can just hear the chip, 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 Mr. President, when we look at it. I would like to begin, though, by thanking all those who have provided briefings for us on the bill. And looking back further than that, those who in the community, as either individual citizens or as stakeholder groups, have taken the time to engage in some of the consultation processes that were provided in relation to this matter and this bill. And it's no small thing, particularly for individual citizens, to do that, Mr. President, to engage with processes, even if it's through a template type submission to make. They are still doing that with a sincere intent to convey their views and to convey their concerns at times, or their support for issues that are being consulted on. And it's important to thank and acknowledge them for that, because at times it must feel like they are doing that fruitlessly and in being ignored in doing it. I also thank other members for their contributions on this bill, which will have been more comprehensive than the one I will give now. And there's much that's been said that I agree with from other members. So I'm just going to pick up on some elements that I want to put on the record as part of my contribution, Mr. President. And to start that, I will take a step back and just revisit the purpose of the Tasmanian Resource Management and Planning System, the RMPS, which the Land Use Planning and Approvals Act 1993, which is, of course, the one we're seeking to amend with this bill, is the key act to deliver that planning system. And I look to the fact that it states very clearly in LUPAA that there are objectives to be furthered, and those objectives are set out in Schedule 1. If we look at Schedule 1, this is what it states in terms of the objectives. It says the objectives of the Resource Management and Planning System of Tasmania are A, to promote the sustainable development of natural and physical resources and the maintenance of ecological processes and genetic diversity, and B, to provide for the fair, orderly and sustainable use and development of air, land and water, and C, Mr. President, to encourage public involvement in resource management and planning. So those are A, B and C. They're the primary objectives. And then it goes on to say, and D, to facilitate economic development in accordance with the objectives set out in paragraphs A, B and C. And E, to promote the sharing of responsibility for resource management and planning between the different spheres of government, the community and industry in the state. I think that's a really important foundation for us to bear in mind when we're looking at this bill before us, Mr. President. I think it's pertinent to remind ourselves and the government that these objectives exist, they're mandated, and quite frankly, it appears that in many regards they've either been forgotten or deliberately ignored in relation to the way this bill has come about and been presented to us. I am going to focus now, though, my contribution on mentioning the key democratic, good governance, transparent planning principles that I think are important for us to have consideration of in relation to this bill. I'm not going to go into minute details of the clauses of the bill, because we'll leave that for the committee stage should the bill get to that stage. So, Mr. President, despite the rhetoric and the chicken little hysteria promulgated by some in the government that our current planning scheme is choked, bottlenecked, apparently worse than peak hour traffic maybe on the southern outlet that I experience at times, we have had some very pertinent, salient facts placed before us by those professionals and experts who work in the planning space in this state about the effectiveness of our planning system here. For example, we've heard from the Local Government Association, LGAT, about some of that in briefings this morning. I know that other members have gone into that data and that detail in their contributions, and I'm not going to repeat the numbers. What I thought was that it provided very valuable data to understand the reality of our approval processes here and the fact that a very, very small percentage of DAs are refused going through our planning system, very small percentage. And of those that do go to appeal, largely they're upheld as being correct decisions made by the planning authority in the first instance. So, Mr. President, my takeaway from the data that's been placed before us, as opposed to the not data or the anecdotes or the absence of data. Anecdata. What an interesting term that is. Yeah. That's right. My takeaway from the actual data is that we should be applauding our system here instead of setting them up to be a scapegoat for what I actually perceive to be fairly crass ideological purposes. I'd emphasise the very salient points made during this morning's briefings, and it was that the Council's high passing rate of discretionary applications and also the rate by which TASCAT upholds Council's initial decisions is attributable in no small part to community and proponent engagement, working together to find appropriate resolution. And I think sometimes this occurs through those formal or informal mediation processes, as we've heard from some examples this morning. The main point being, under the proposed bill here, the DAP bill, those proven successful engagement, consultation, mediation processes, I fear, may be largely set aside on these particular matters that go through the DAP process. And in fact, given the nature of those particular sorts of projects that would be put through this process under this bill, they're probably the sorts of projects that would best benefit, not from being taken away from engagement, consultation and mediation processes in the current system and put elsewhere, but actually from being put through those processes so that we come out the other end having projects and proposals considered in ways that bring people together ultimately, rather than having contention stoked and the community being felt to be set aside. I think it's a regressive approach, Mr. President, to go down pathways that take us away from community engagement and ownership of outcomes and give special consideration to particular interests. Mr. President, I note the property development sector points to stalling of developments, and then they actually provide quite a list of factors contributing to that stalling. And among that list is some form of holding up occurring in the planning approval process. But I have only heard them speak to that anecdotally, without actual data or evidence to demonstrate exactly how much of a factor this represents or the specific problems that are needing to be addressed to fix that apparent blockage. Pointing to anecdotal examples of DAs that ran into problems or delays is not a robust basis for forming policy or legislation. It's a given, I would have thought, that every DA application will be unique, and despite what occurred in this place yesterday, we cannot provide everyone with a bespoke legislative approval process. We need to have a system which is fair, transparent, consistent and accountable. We need a system that is based on natural justice, that has checks and balances, and that is unbiased. The system we have now may be far from perfect and in desperate need of an overhaul, but it is explicitly based on those fundamentals: fair, transparent, consistent and accountable. Our commitment should be to improving that system, not finding ways to work around it. Mr. President, let me flag my disquiet at the fact this bill appears to be driven by ideology rather than the principles of good public policy or the objectives of our RMPS. Nothing shrieks more loudly of ideology than phrases such as taking the politics out of planning. The government PR spinners clearly think they're on a winner there. Let's break down this hypothetical problem of local politics as it's mentioned in the government's second reading speech in the bill package. Local politics, Mr. President, Madam Deputy President, pardon me. What exactly does that mean, and why exactly is it a problem? Local politics is the community. Community consultation isn't just providing people one opportunity to shout into a void, only to be ignored. Local community representation is about genuine listening of expressed views, engaging with those expressed views and testing those expressed views in a democracy that actually values, instead of paying lip service to, community involvement.
We don't have a quorum at the moment. Could we ring the bells? Now that we have a quorum, we can stop the bells and the member can proceed. Thank you.
Thank you, Madam Deputy President. I was saying, in a democracy that actually values, instead of just paying lip service to community involvement and diverse opinions, it's natural for there to be a tension between different views. And you know when it is that people get angry and when those tensions risk boiling over, Madam Deputy President? It's when people feel they are being ignored and locked out of decision-making processes which affect them, which I think this bill threatens to do. This isn't about taking local politics out of planning. It's about taking legitimate community involvement out of decision making. It isn't about a development assessment process. It's a privileged approvals process for a few.
Yep.
Madam Deputy President, the objectives from our RMPS clearly place community involvement front and centre. In contrast, the so-called consultation process for this bill reveals worrying contempt, I think, for genuine community or stakeholder engagement. Despite a rushed consultation period on the draft bill, there was, however, a total of 482 submissions received. Of those, 461 were received by the closing date of 12th of November, and a further 21 came in a bit late. And of the total of 482, 440 opposed the DAP's proposal in this bill. And that equates to 92% outcome against the proposed DAP bill. Yet a mere 7 days later, the government tabled the final bill in the other place. 7 days, apparently, to consider in a thorough and respectful manner 482 submissions, even though, granted, a number of those were based upon a template expressing similar views. We know LUPAA was still meeting at that time that the bill was tabled, still meeting and planning to meet to formalise its response when the government charged off and brought that bill on for debate in the other place. LUPAA, the peak for the very sector that this is most relevant to, was still in the process of bringing together that sector to formalise their actual response to this. But of course we couldn't wait for that. We rushed ahead and pushed it on through the other place. We heard that after making submissions to the government's position paper from 2023, the local government sector stakeholders felt that they were then not engaged with further in an effective way until the draft bill appeared this year. That doesn't seem to be a mistake, Madam Deputy President. It seems to be a deliberate rebuff of arguably central stakeholders. That's exactly how it looks from the outside when you have those central stakeholders tell us that they felt that there was no engagement with them in a meaningful way to develop this bill, which they had stated an openness to in its central proposition of putting in place a DAP process. It's not the central proposition that they object to, it's the way it's been done in this bill. So, Madam Deputy President, I just don't see a world in which any of us would consider that that was acceptable behaviour by a government, a decision-making government. It is not, further to that actually, it is not an edifying sight to see the Premier then publicly disparaging feedback from 4 Greater Hobart mayors as nothing more than self-interest and grandstanding.
It's disgusting.
Taking the politics out of planning, indeed, Madam Deputy President, is certainly not what we saw from the Premier that day. And I feel that it was shockingly disrespectful to representatives of their local communities, which in fact was then confirmed to be a shared view of all unanimous 29 councils around the state by their peak body. In contrast, Madam Deputy President, should a developer complain about a decision arrived at through due democratic processes, we don't see them publicly vilified and demeaned by the Premier.
No, they get their own legislation.
And in fact, that would be a situation in which we would be seeing the very definition of self-interest, actually, complaints from a developer, the very definition of self-interest. But that's not labelled and vilified. Instead, they get, as the member for Hobart said, she must have read my notes, their very own standalone piece of legislation, Madam Deputy President.
That's the second member she's read their notes.
Yeah, this is my superpower, okay? Just be
deeply
careful.
worrying.
Read minds.
It's a deeply worrying situation, Madam Deputy President. The Minister in the other place has stated that while reducing the role of local councils, the bill does not remove completely their involvement, and that while they are not completely absent, they are not the decision maker. Let's just pause and think about that for a moment. Local councils are not the decision maker. Democratically elected representatives elected by their community peers to make decisions on the community's behalf, set in our legislation as the decision makers, as the planning authorities primarily, are having that role ripped away from them in relation to these particular projects and beyond their control in terms of who decides that those particular projects go through a DAP process. This democratically elected tier of government is basically being told, possibly you may be allowed to make a decision, but if the developer thinks you might make the wrong one, they can choose to go down this other path. Madam Deputy President, we know there has always been the perception and risk that powerful vested interests get special treatment and consideration. But this bill seems like a step towards codifying that.
Yep.
It was also suggested in the other place that controversial matters may be best removed from council's hands as they are put under immense pressure to vote contrary to planning schemes, apparently. Well, that smacks of infantilism, Madam Deputy President. I'm concerned about that. It's interesting too when you think about it, because actually our planning scheme, and let me just say, I am not someone here with a local government background, so I'm not speaking from personal experience, although I very much appreciate hearing from others who are. But what I'm given to understand, and in fact I think it was brought up in our briefings this morning from Legat, that there is a great deal in our planning system and our scheme that isn't just black and white. You comply or you don't. There are many aspects of it where there is an element of discretion or an element of grey area or a sliding scale of something. And it is in that place that the elected representatives in our local councils can bring their decision making to bear. Yeah. So they may have something recommended to them by their planning officers, but if they decide different to that recommendation, it isn't always that they are contravening the planning scheme to do that. Their decision may still sit within the planning scheme but be different from what was recommended by planning officers. And let's be really clear, if they did make a decision that did technically contravene the planning scheme, presumably that would be the basis for an appeal that would be available to the proponent. And we know when appeals are brought that actually, by and large, decisions are made by TASCAT upholding the original decision. So I'm very comfortable with the fact that elected members at a local government level bring to bear in that space decision making that may be different from recommendations made. The recommendation might comply with the planning system. The decision by elected members might also comply with the planning system. And we have an excellent process in place for independent appeals to be heard if there's any contention about that. So, Madam Deputy President, instead of patronising the local government sector, maybe the state government should prioritise its own responsibilities instead and actually address the long-standing and problematic outdated planning scheme that others have identified as being there and being in need of attention. Would we consider it appropriate to have our rights and responsibilities as elected representatives removed because apparently we couldn't cope with the risk of being pressured over controversial matters? I don't think we would be happy with that in this place, Madam Deputy President, and I don't think the local government sector should be happy with that either. We have been told that a proposal taken to a development assessment panel is final with no right of appeal based on planning, based on merits, and that's apparently somehow still reflects a commitment to natural justice. And I just have to ask, for whom, Madam Deputy President? How does the removal of access to a merits-based appeal comply with the principles of natural justice and appropriate administrative decision-making? That is a well-accepted principles. We've got an excellent memo provided to us by Anya Hilkemeyer and Professor Jan MacDonald from Cleo Hanson-Lowry and Dr. Philippa McCormack and Dr. Emile Boulot from UTAS Law School. And they lay out very clearly the fact that a legally sound administrative decision requires that decision makers have very key factors, that they have access to all relevant facts, that they have sufficient time to consider how applicable legal rules apply to those facts. And it is their contention in this memo that it also should include administrative decisions being subject to merits review, that they are fundamental to good governance and good practice, and that this bill falls short on all three of those basic requirements. They point out very clearly that commission panels are no substitute for a TASCAT review process, that a review process being available, because we're excluding TASCAT with this bill, and we're excluding then that independent review process that TASCAT provides. A commission hearing, they say here in their memo, a commission panel hearing is no substitute for TASCAT review for the following reasons. It is logically impossible for a decision maker to review its own decision. The fact that a commission panel conducts a hearing before finalising its decision is not a substitute for independent merit review of that decision. And secondly, commission panels are not designed to be as transparent, procedurally fair, comprehensive and independent as TASCAT panels. So, Madam Deputy President, they also set out very clearly a set of 4 key ways that commission panel processes may not meet natural justice standards. In the interests of time here in this place, I'm not going to read through all of them, but just to mention the areas they touch on. Commission panel hearings are time limited. They're constrained to a particular time frame which amounts to 18 calendar days, because although it's 28, it can't start till 10 days after the exhibition period. So they are a constrained time period. They can't get an extension to the hearings time period. They can get potentially an extension to the ministerial, from the minister to the final decision time period, but not the hearings time period. So they're very constrained in how long they can spend receiving information through that public hearings process. They're required to finalise the decision within a very particular time frame too. The minister and the applicant can seek to grant an extension for the making of that final decision, but that's a very self-interested group of people who can do that, the minister or the applicant. The draft assessments are made without hearing from all the affected persons, perhaps. And also commission panels do not provide written reasons for their decision. So that's just a few. There's a lot of detail in this memo, and it's a shame we're not able to. I should have probably sought to table it, but I've got a very messy version here, Madam Deputy President, so I won't. Suffice to say, I have serious concerns about the appropriateness of this administrative decision-making process and complying to what we would all understand to be the standard foundations for that process, particularly in relation to appeals. I find the matters raised around the need to support this to help address affordable and social housing outcomes particularly problematic, Madam Deputy President. And I can hear already the government accusing people who oppose this bill of somehow putting barriers in front of much needed social and affordable housing in this state. And I would absolutely stand firm in the face of that. My roots are in social justice and the community services sector and the housing sector as part of that, Madam Deputy President. And I will not stand here and be gaslit by anyone suggesting that I would put things in the way of that in an unwarranted fashion. And I will also call out when I see vulnerable people and issues, such as a lack of housing, being exploited for blatant ideological purposes, which I think partly in this case they're conveniently being used in that way. If the government and the planning minister were genuinely driven by a desire to address our urgent need for appropriate, safe and livable social and affordable housing, they would have prioritised urgently needed revision of the planning scheme, which is in fact struggling effectively to deal with mid to high density proposals. They would have done that differently. If the government and planning minister were genuine about getting roofs over heads now, they'd take meaningful action to stem short stay accommodation, which is suffocating our housing market, and place some meaningful control in the hands of local government to decide what's best for their communities on that front. And I would say to the government, do that first. Attend to your own legislative backyard before you come looking to circumvent key democratic principles in this way in this bill. So, Madam Deputy President, to conclude, what is the problem this bill is seeking to fix? In my assessment, there is no clear and evidenced demonstration of a problem. It seems anecdotal and multifactorial, more a case of the vibe of the thing. Yet despite that lack of problem definition, we see with this approach the fingers of blame squarely being pointed at that messy thing we call democracy. The irony of having this government, which has made an art form of lambasting non-elected entities or scientific experts or statutory bodies who may try to tell them what to do, suddenly embracing non-elected bodies to do the work of an elected tier of government as a planning authority. It's quite astounding, Madam Deputy President. Apparently, as a planning authority, local government may not be able to withstand potential political interference. They could succumb to conflicts of interest. The Minister, however, who under this bill retains considerable power, will apparently always act apolitically and never be at risk of a potential conflict of interest, either personally or on behalf of their party. How very reassuring, Madam Deputy President. The Tasmanian people have a right to be passionate about where they live, both in terms of the immediate and the long term. This is reflected by the legislated objectives in our RMPS. People should be involved in decisions that impact where they live, where they have chosen to bring up their family or to retire or to work, rest or play, Madam Deputy President. People should be involved in their local planning processes. How often have we stood here recently and been castigated by the government about the need to protect the Tasmanian way of life? Really. We've had to apparently risk interfering with a Supreme Court action in recent times to protect that Tasmanian way of life. Well, I can tell you, Madam Deputy President, what the Tasmanian people value as a pillar of their way of life is a democratic, accessible, transparent and equitable planning system, as recognised by the objectives in our RMPS. A key factor of the Tasmanian way of life is equitable access to merit-based appeals at the very least, Madam Deputy President. That shows that we are all equal before the law. This bill does not remove politics from planning. Instead, it centralises and insulates political power in the role of the Minister and in the absence of merits-based appeal rights for projects that are most likely in need of them. Rather than removing politics from planning under this bill, ordinary people are removed from the planning process. And I'll finish up by reiterating my concerns about the poor precedent this bill sets by eroding democracy by stealth. Madam Deputy President, I commend to this place the Tasmanian people's right to a robust, sound, transparent and democratic planning system. And on that basis, I cannot support this bill, which I think is anti-community and anti-democracy.
Hear, hear.